Attorney Steve Vondra, and welcome back to another exciting episode of Litigation Whiteboard. We are talking in this video about boxing piracy. And without further ado, let's head to the Attorney Steve Litigation Whiteboard. Let me put my boxing gloves back up here. Okay. All right, sorry. Hope you're all having a great Sunday. Just trying to have a little fun here today. I have my boxing gloves up there always. You know, litigation is a lot like boxing. You got to be able to throw punches, but you got to be able to take them too. So when it comes into the area of boxing piracy, the question becomes damages. Now, let's talk a little bit about this, okay? So say you own a restaurant. Here's my restaurant. You own a restaurant, tavern, sports club, nightclub, hookah bar, tattoo parlor. We've seen all kinds of things. We had a lot of these cases, okay? So what happens, basically, you're showing the fight. You're showing a fight, heavyweight, lightweight, middleweight, some kind of fight at your establishment. And what usually happens here is it's going to start with an ad. You run an ad in Facebook or somewhere other social online media that says, come on in, come one, come all. We're having the big fight here. It's a heavyweight. It's going to be the fight of the century. We got drinks. We got specials. We got dancers. We got everything's going on. Come on down. Now, what happens is these companies are not paying the commercial fee. The commercial fee. Companies up here like Johan, JJ, these companies, they own the commercial rights to broadcast and publicly display the boxing matches. So you got to get your license through them, and they're going to charge you. It could be a couple $1,000s. They're going to charge you based on your head count, your occupancy levels, and things like that. So there's a fee to be paid. And what they have to do, if you look at it, there's your restaurant, there's other restaurants. They have to protect their intellectual property rights from their paying customers. These people are paying. They don't want somebody next door showing it for free. You see how that works? These guys might be charging cover charges. They pay thousands for the fight. Anyway, so these companies are out enforcing their intellectual property rights. And if they find out that you're running ads, they get a little team out there. They find out. They send out an investigator. Okay, here's your investigator. Comes out with a video camera. Looks at all the cars in the parking lot here over here. Looks at the cars in the parking lot. Says, you know, I see 25 cars. Goes inside, starts videotaping around, seeing all the customers. Sometimes they're shooting videos of the waitresses that I think, you know, anyway, I'm not going to go into that. But they go in, they start shooting videos everywhere, and they try to, you know, basically documents what's going on. Is there a cover charge? Is the manager in there? Who's in there supervising? Do we know? Those kinds of things. So the ad is always what kicks off the investigation, I would say usually. Now, there's not always ads, okay? Sometimes they get wind otherwise that this is going on. But the investigator's getting paid by this company to basically go out and see what's going on and report back. And they give their report in the form of a declaration or an affidavit. And they say, here's what's going on. Here's what I saw. It was up on 5 TVs. The place was packed. Oh my gosh, you know, this is a big one. Okay, so then these companies will then hire the law firm. The law firm, we got past the investigation, law firm will come, and usually they will reach out to the bar owner or the restaurant owner, and they'll say, you're in big trouble. We're going to sue you for federal court violations, Section 605 of the Telecommunications Act, Section 553 of the Telecommunications Act. We're going to sue you for copyright infringement, okay? So you owe big money. And so what happens is they come after you and they start throwing big numbers around. Believe me, we've seen them as high as 50,000, you know, 30, 20s, you know, 10s. We see all kinds of numbers being thrown around. The question is, can you afford it? Can you work out a settlement? What happens if you can't? A lot of times you have a small company here, and this person, the manager over here, manager may be working 2 jobs and says, look, I have no stake in this company, no financial interest, but they're naming me. I wasn't even there that day, matter of fact. So things like that can happen. But in this video, I'm going to talk about the default judgment. What happens? They start asking for, you know, 20, 30, 40 grand over here, and you just can't pay it. They will file lawsuits. There are so many lawsuits on record is you have to take it serious because there are so many lawsuits. That's all I can tell you. Each one is a little bit different on how many they file, but they do file. Now, what happens if you're saying now you just can't pay it? We don't have that. You might have to go into default. And so let's say you can't afford the settlement and they say, okay, fine, we're filing a federal court lawsuit. Boom. They file the lawsuit. They name the 605. That's your satellite and radio interception of a satellite and radio signal, and your 553, which is a cable. Now, usually they're going to allege both, but in theory, they can only recover on one. Usually it's the 605, okay, and that has its own set of damages. The 553, same difference, but anyway, and copyright infringement. Why? You are publicly displaying a copyrighted fight without the proper license. They will call that copyright infringement. They will seek copyright infringement damages, which can be steep and very hefty. Now, the courts have said that they can recover, it seems like a double dip, that they can recover both for this and for copyright infringement. So you have to be aware of that, so you can have two penalties. But the court has wide discretion to formulate a just reward, okay? So let's say you just get in, the lawsuit's filed, you go, well, I don't have the money, I'm going to take a default judgment. If you want to know more about default judgments, make sure you watch my video, Attorney Steve Default Judgment. Google that and you'll see my great video on defaults. But you go into a default and you say, well, what's going to happen now? When you do a default, you admit all the allegations made, all the well-pled allegations made in the complaint, those are deemed admitted. So you can't come in and change it later and go, I changed my mind. You admit all those things. So that is number one. They get a default, and then the question becomes the prove up, the damages, okay? So likely they will have to prove up the damages. The court will be looking at the affidavits of this person. How many cars? How many people inside? Was there a cover charge? How many TVs was it showing on? How much money did they make? Is this the first time or the second time this has happened? Those kinds of things. So all these things are going to get weighed. The court has the discretion to set the damage fee, okay? And so in a case that I had here, it's a New York case. It's on the floor now. Don't ask me how it ended up down there. But it's a New York case where the case went to default, but only about $4,000 was awarded. Only about $4,000. So that could be significantly less than you're facing here at the demand stage, where somebody may be going, oh, it's 20, it's 40, it's 20, it's 50. That's all. We're not taking any less. So $20,000 to $40,000. So in this case, the default was for about $4,000. The court hit them for damages here and damages here and for costs and attorney fee, but those were, kind of minimal because there really was no contest. There really was no litigation going on. So in this case, the judge awarded about $4,000. I think it was even a little bit less than $4,000, which for the defendant was probably a good day. The court said there was not enough allegations about the manager, even though you may think, well, I have the corporate veil. Managers, people with a financial interest in the piracy, can be held liable, especially if they had the ability to control. But you have to make those proper allegations. If those allegations are not in the complaint, if they're deemed conclusory by the court, then you may not be able to hold this person personally liable, and you may only get limited damages against the restaurant. So it's very important when you get a letter or you get a phone call. Sometimes you get a phone call, somebody harassing you on the phone for money. Yes, it happens. Give us a call. Let us take a look at your complaint. If there's a complaint filed, if it's not a complaint, let's take a look. But in here somewhere is probably your settlement in here. But there are, like I said, sometimes they're going to hit you so high, they're unreasonable, and really the damages could end up down here more in the $4,000 or $5,000 range, okay? So it really matters how you want to play your hand. There is no perfect way to play it. Every case is different. This is not legal advice. This is general legal information only. Every case is different again. So we offer a low flat rate fee to check this stuff out for you. We'll see who you're dealing with. We'll see who the attorney is. We've dealt with most of them. Okay, so give us a ring. You can find us on the web at attorneysteve.com. That's attorneysteve.com. My jaws are all. Whew. Okay, have a great Sunday. We'll be back. We got some great videos coming up for you next week. Make sure to subscribe, okay? Take care now.